Welcome to today's episode. The case we're about to examine features one of the most volatile courtroom confrontations we've seen so far. From the opening exchange, it's clear this hearing is about to spiral.
Please. Who's here?
Quashante Short, QASHONTAE SHORT.
Richard Jordan.
Hold on, wait a second, did he really just say Richard? Because the way that name hit my ears completely changed the energy of this case, and now I cannot unhear it. The courtroom is supposed to be serious, but somehow this just turned into accidental comedy, and I am trying to stay mature about it, but the wordplay is fighting back, because when you put it together like that it sounds like a headline from a chaotic reality show, and the craziest part is this case only gets messier from here, so if you thought we were starting calm, you are already wrong. Buckle up because this is about to spiral fast.
I read your complaint again, and you have not, I'm looking here, what is it, intentional infliction of emotional distress?
Yes.
Is that the claim here?
Yes,
Okay.
It is.
That's not something that's really justiciable in district court.
I'm sorry. I can't hear you.
I said that's not something that's justiciable in district court. That has to be brought in circuit court.
So you said it's not permissible in district court. It has to be taken to circuit court.
That's an equitable action, yes. Mm-hmm.
I thought only criminal offenses. Oh, well, I guess it would be considered. I don't know if it's criminal or however you want to consider it, but I thought only criminal offenses were brought before the circuit court.
That was her first costly mistake because she filed in district court when her claim clearly belonged in circuit court, and after suing A.T. and T. Cox and even filing a $300 million lawsuit against multiple police departments, you would think she would know the difference, but somehow we are here, and before anyone feels too harsh, remember, she did try to be generous by offering a discounted $10 million per year for 2.5 years, which is apparently what passes for compromise in her world.
So will I have to?
What's in your head? I cannot get into what's in your head, man. Mr. Jordan, let me just ask you this: are you planning to represent yourself on this?
To be honest with you, sir, I thought this was just going to be thrown out. We had a date, one date, and nothing else after that. And now I'm being sued for $10,000.
$10,000 for one date is wild math because at that point, we are not talking about heartbreak, we are talking about premium luxury trauma pricing, and I am trying to understand how one awkward dinner somehow turned into a full-scale emotional catastrophe invoice. Like, did the appetizer insult her childhood? Did the entree reopen generational wounds? Because unless that date involved a marching band of red flags and a live reenactment of every bad decision ever made, I am struggling to see how we jumped straight to 5 figures for emotional damage at that rate. Even Schrodinger's cat would open the box, take one look, and decide reality itself is confused.
If you think it should be dismissed, you need to file the appropriate motion. You need to file a motion to ask for that.
I will do that. I really didn't know what to expect. This is all new to me. I've never been sued before. I've never, gotten in any trouble. This was just, I don't know. But if that's the process I have to take, then that's what I'll do.
There was also a perjury on there as well. He stated, I can't remember what he stated right now because I don't have it, the document
Perjury,
in front of
the short,
Yes.
perjury is a criminal charge.
Okay, there were two different charges. There was one that was intentional affliction of pain, which
Okay, pause, because that is not even the right legal term. The word you were reaching for is infliction, not damage. And if you were going to throw around phrases like intentional infliction of emotional distress, at least get the language straight, because the irony here is if anyone intentionally inflicted emotional chaos, in this situation, it might have been self-administered. You cannot fumble the terminology and then act like you are delivering a legal masterclass. That is not how this works. That is not how any of this works.
was not, I didn't see that as being a criminal offense, but perjury, I guess that could be considered a criminal offense.
Ma'am, I'm not going to sit here and argue about the legal definition of what's a crime and what isn't. If somebody gets charged with perjury, that is a criminal felony charge. You have to go through the prosecuting attorney and the police. Okay? So that's what you are alleging.
Yes, the document will show that, and I also sent forth the messages where he was lying, and it proved he was lying.
Just because he rounded up his height from 6'1 3/4 to 6'2 does not suddenly transform a first date exaggeration into a felony offense. This is not a courtroom drama about perjury. It is a mildly inflated dating profile. And we all know half the internet adds a little confidence boost to their stats. You cannot cross-examine someone over a quarter inch like it is sworn testimony under oath that is not fraud, that is ego with good posture. So filing a lawsuit over that is less about justice and more about turning normal human nonsense into a legal thriller nobody asked for.
But that should have been in the case file as well.
Did you put it in there?
I emailed it.
I don't see that mentioned in your complaint.
Yes, I emailed that.
Did you amend your complaint?
I didn't have to amend my complaint. I had to get an address for him, so I sent it to the second known address.
No. If you are alleging a different count, you've got to amend your complaint to add it in. You can't. I don't know what you said you did, but you.
No,
the
last time we spoke, the last time we were in court, I never changed anything. It's just that he was not properly served, so I had to get an address for him in order for him to be properly served. That's what was the last incident that transpired, was for me to get a correct address for him.
That has nothing to do with what I asked you about.
I know you asked me about an amended.
I asked you about what your claim is about. You said intentional infliction of harm, and I assume you mean intentional infliction of emotional distress. And you said perjury. That's the basis for your claim.
Yes, I'll amend the complaint. I thought I had that already in there. I received a document, I guess after I sent the correct address and he got the document, he sent a letter that should be, I guess, in the file. He sent a letter, and
that's
then
his answer, I guess. We're treating it as his answer.
Right. And so I emailed my response to that letter, because in that letter he lied. And then that's what brought forth the perjury. It was never perjury in the beginning. It was perjury after his response.
Right. Perjury only happens when someone lies under oath in an official legal proceeding, like in court or during a deposition. A random lie on a date is not perjury, it is just regular dishonesty, and the law does not treat those the same at all.
Well, you can't say, listen, he has the right to put whatever is in the answer.
I'm not saying he can't, but
you can't add another count because you don't like or you disagree with what is in his answer.
If he responds and his response is a lie, it's perjury, then my documents will prove that he lied in his response.
No.
All right, now it's time for Karen to crank her chaos over 9,000, and of course, Dick is just sitting back enjoying every second of the drama, because some people live for this level of absurd energy, and honestly, the courtroom just became a front row seat to pure entertainment.
First of all, do you understand what perjury is?
Yes, I understand perjury is a lie. I know what perjury means.
Perjury is a statement, a false statement made under oath. So
exactly, and I got documents that prove he was lying.
You don't understand. It's a false statement made under oath.
That stated a lie.
When did he testify to something that he lied about? It's a false statement made under oath.
Bottom line is, you said it's a criminal offense, so I will send it to circuit court. Are we done here?
Oh no, Karen, we are far from done. In fact, this is only the beginning, and the judge is about to go full mask off, exposing the chaos for everyone to see, and things are about to get way more intense. because nobody warned her the real storm was just walking through those courtroom doors.
No, you don't understand, ma'am. You don't understand.
Are we done here? Are we done here?
Perjury is a false
I know exactly what perjury means. I know what perjury means. Are we done
no,
here?
You don't.
Is it a criminal offense or not?
What statement? I don't see anything in the complaint that says he made some false statement under oath.
Because you don't know what happened. You're on the outside looking in. You don't know anything.
But you're the plaintiff. Wait a minute. You are the plaintiff.
Are we done here?
You have to lay out your allegations properly.
Are we done here?
No, we're not.
Exactly what perjury means.
No, we're not.
Do not insult my intelligence.
You have to
do not insult my intelligence.
You have to lay your complaint out. You have to allege this in the complaint. You have not.
Please do not insult my intelligence.
Yeah, exactly. Get it right, Judge, because no insult could ever reach the level of the impossibly stupid court Karen. She is operating on a whole other plane of chaos and cluelessness, and every word just bounces off like a trampoline of pure absurdity.
It's not about that. You don't think. I don't think you understand what perjury is. It's a false statement made under oath.
Are we done here? Are we done here? Please do not insult my intelligence.
I said no.
Do not do that. Do not do that. Do not insult my intelligence as if I do not understand what the word perjury means. Do not. If it's a criminal offense, then it's a criminal offense.
Well, ma'am, it should not have been filed in district court if you want intentional infliction of emotional distress.
Okay, so that's a criminal offense.
Are you going to dismiss it and refile it?
No, I'm not. No, I'm not going to dismiss it. I will file another case in circuit. But as far as I'm concerned,
you can't have two cases on the ma'am. You can't have two cases going on the same issue.
Well, I'm not dismissing the case. If you want to dismiss it, that's up to you. But I, as a plaintiff, am not dismissing the case.
He has to make a proper motion.
Well, that's on him.
But I can also transfer the venue to circuit.
Yes, that's what I thought, because there were other cases that should have been transferred somewhere else.
So if that's what you thought, then why on earth did you file your case in the wrong court to begin with? And why would you even want it to go to circuit court, which is way tougher, especially for legally illiterate troglodytes like yourself? Because at this point, it's clear you have no clue how the system works, and yet somehow you keep marching straight into the deep end, thinking you're playing chess, when really it's just basic checkers.
Okay, I'm going to do that. Ma'am, what about his costs associated with appearing because you filed it in the wrong court?
I need to see because I was not aware, since you said perjury was not on there, I was not aware that a criminal offense for intentional infliction of emotional distress was considered a criminal offense there, that it had to be.
I didn't say that. That is not what I said.
Yes,
that is not what I said.
That is what you said.
That, sir, no, I didn't. You
yes,
said
you
that.
Did. You stated
I said that circuit.
You stated that the criminal, you stated that emotional infliction of emotional distress is a criminal offense. And you stated that perjury is a criminal offense. But you also stated that perjury is not on the document that I placed forth before you. So criminal offense would not.
It's not in the complaint.
On there.
It's not in the complaint.
I need you to show me. I need you to show me the document which states that intentional infliction of emotional distress is indeed and in fact a criminal offense, because that's the original offense that was placed on there.
I never said that. I never said that.
Yes, you did.
I never said that.
Yes, you did.
No, I did not. Ma'am,
yes, you did.
Listen. I'm not going to sit here and go back and forth with you. I will repeat to you what I said.
I'm not either.
I said
that's
that intentional. You need to be quiet while I'm talking. You need to be quiet. Can you mute her, please?
Because perjury is a criminal offense. It has to go to circuit court.
That will not make her hear you.
Intentional infliction of emotional distress.
What I said was intentional infliction of emotional distress is something that circuit court has jurisdiction over. I never characterize that as a criminal matter. It is definitely a civil claim, but it is something that can't be done in district court. Now, that's what I said to you. You are of the mistaken belief that circuit court does not hear civil matters because you said, well, I thought circuit court only did criminal. You are the one who are mistaken about the jurisdiction of circuit court, because that's what you stated on the record.
I can barely hear what you're saying. Like I said, I'm at the airport. There's a lot of people around.
Ma'am, are you getting ready to go on a trip or something?
No, I actually just came. I had a rental car.
Oh, I see. Okay. Ma'am, this is what I'm doing. I am ordering that this go to 7th Circuit Court. Venue is to be changed because intentional infliction of emotional distress is a circuit court matter outside the jurisdiction of district court. Plaintiff shall pay the filing fees in the receiving court. And I don't know if you asked for a jury trial or not. You did not, it looks like. So there was no jury fee. No further proceedings shall be had after transfer until these costs or expenses are paid. If not paid within 56 days of the date of this order, this case shall be dismissed by the court to which it was transferred.
And what cost am I paying? Hold on. What cost am I paying for?
The filing fees for circuit court.
Why am I paying for filing fees for the circuit court? Because there's been multiple cases that have been brought forth.
Because you filed it in district court, we don't do intentional infliction of emotional distress cases.
Well, I need to see that in writing.
Well, you need to learn how to read first.
I need to see that document in writing that states that
if you want to appeal, if you want to,
I've already skimmed SCAO. I've already skimmed that. I'm reading constantly every day, and I did not see that form on there.
I'm sure that you are. But
yes, I am.
If you want to appeal my ruling, you got 21 days to do it.
Yep, I do.
You got 21 days to appeal it to the circuit court. My ruling. Okay? Thank you both.
All right, that's where we're leaving it. She has 21 days to file an appeal, and if she doesn't pay the court fees within 56 days, the court will just dismiss the case, and honestly, I highly doubt she's going to spend a single penny to push this any further, but I'll be keeping an eye on it for sure. I found this clip on Old Squishy Gardener's channel, so if you want the uncut version, head over there and tell him Team Skeptic sent you. And if you enjoyed this video, leave a like, if not leave a dislike, but don't forget to comment and subscribe with notifications on so you never miss my content. I'm Team Saju Shah, and I'm out.